Good afternoon, everyone, and welcome. We're pleased to have you with us today. We originally had 3 cases on the docket, but one has been continued. The other 2 cases will be heard in the order in which they appear. The first case is actually a consolidation of 2 separate appeals. As a result, the court has agreed to give the appellants and the appellee additional time to argue their case. Let me remind the appellants not only the first case, but the second case. You have the right to reserve up to 5 minutes of your allotted time for rebuttal. So when you come to the podium, after you've introduced yourself, please let us know how many minutes you wish to reserve, and the clock will be programmed accordingly. Are there any announcements or introductions? Hearing none, please call the first case.
Lisa Garramone versus Tommy Duggar et al.
Good afternoon.
Good afternoon, and may it please the court, I'm Jeffrey Sheehan, representing the appellant, or one of the appellants, and the successful petitioner below, Jason Patrick. I'm here with Mr. Kritzinger's counsel, Mr. Davis, and pursuant to the court's order, we would ask that I be allowed to use 12 minutes in my affirmative argument, that Mr. Davis be allowed to use 8 minutes in his affirmative argument, and that we be allowed to reserve 3 minutes for my rebuttal and 2 minutes for Mr. Davis's rebuttal.
All right, we'll start out with you with setting the clock at 12 minutes. Thank you very much.
Thank you, Your Honor. This case is a poster child for the Tennessee Public Participation Act. Mr. Patrick and former Commissioner Lisa Garramone are perfect examples of exactly whom the General Assembly had in mind when it passed the TPPA. That remedial statute dictates that courts shall award to a successful petitioning party the court costs, reasonable attorney's fees, discretionary costs, and other expenses incurred in filing and prevailing upon the petition, and any additional relief, including sanctions, that the court determines necessary to deter repetition of the conduct. Today, Mr. Patrick asked the court for relief from a July 2023 order awarding less than 1/3 of the reasonable fees he paid to prevail on his petition and costs that don't even include the court reporter expenses for the first hearing on that petition. The root of the error here is the trial court's invention of a foregone conclusion limitation on the Act's mandatory fee-shifting language. Looking for the moment when it became clear that Mr. Patrick should prevail on his claim narrows a remedy that the legislature directs courts to construe broadly. That limit has no textual basis in the Act. Instead, it offers a blueprint for the abuse the legislature enacted this substantive remedy to deter.
Well, the Act, particularly Section 107A, refers to the right, mandatory shall, recover attorney's fees and costs incurred in filing the TPPA petition and in prevailing on the TPPA petition.
Yes, Your Honor.
Aren't those limiting terms?
They are, but those limits encompass the entire period between when Mr. Patrick began litigating this case and under Nandagam, this moment, Your Honor, because he is still seeking to prevail, at least at the trial level.
Well, didn't he prevail when Ms. Garramone filed the notice of voluntary non-suit?
He did not, Your Honor.
Okay.
The notice of voluntary non-suit, as the district court or as the trial court held, was ineffective. It did not invoke any right that she had. It did not work around Rule 41 and find some other avenue. At the time that was entered, it was a nullity. It has no basis in law, and the trial court so held. Especially as to Mr. Patrick, it could not have any effect.
Because of the motion for summary judgment?
Yes, Your Honor.
All right.
What's wrong with the trial judge's analysis here that there really were only 2 potential outcomes? Either the voluntary dismissal is granted, in which case the substantive case against your client ends, or the TPPA petition is granted, in which case it comes to an end. And isn't part of the trial judge's concern here that further discovery was going on almost with a vision of the case going and being tried on the merits when it was never going to be tried on the merits in this case?
So there are two parts to your question, I think, Your Honor. And on the first question, I think the trial court was absolutely correct that there were only a narrow number of possible outcomes. And while we could see that Mr. Patrick would prevail, should prevail, must prevail, that's not the same as him actually prevailing. He was still a party until he received a judgment from the trial court granting him the remedial relief that the statute allows. At the point that it becomes obvious that, which Ms. Garramone was at the very beginning, that her case had no basis, that it was an abusive slap case, the statute shifts the risk to the bad faith slap litigant and says, you are going to be on the hook for this. And Mr. Patrick gave her every opportunity to get out. It really does shift the risk. It shifts the concept of the American rule over to an English rule, where the prevailing party here, especially where there is no basis for the claims and the legislature has specifically moved forward to try to quash these, that risk had shifted. And so it's not Mr. Patrick's obligation at the point when it's clear he's going to win to stop litigating. He didn't have the option of not responding to Ms. Garramone's late filed exhibits. He didn't really have the option of failing to show up for the hearings and hoping that the court would not treat that as a waiver or as a forfeiture of his demands. So the court was right that Mr. Patrick was going to prevail, but the logical consequence under the law is that Ms. Garramone needs to recognize that and either accept the offer that Mr. Patrick made to end the costs, to stop incurring costs on either side, and settle it out for the costs that had already been incurred that she was bound to pay. I apologize, I have forgotten the second piece of your question.
Is there, with regard to how this comes out, and is it still reasonable to be investigating the merits with regard to the claim at that stage? I mean, there wasn't going to be a merits trial here, and it was either going to be voluntarily dismissed or it was going to be dismissed under the TPPA, and one of those two outcomes had to occur, right? And there wasn't a third way, essentially, and given that is the continuing and expenses related to discovery, preparing, and were those reasonable expenses at that stage?
Thank you for reminding me of that question, Your Honor. And I think it's worth saying the expenses that actually were incurred during that time period were not additional discovery expenses. If you look at the trial court's order references February, and it's not clear if it's talking about the February invoice or the March invoice showing February expenses. But the February invoice at trial record page 356 involves me working to respond to Ms. Garramone's late filed declaration. That was a direct consequence of her continuing to add evidence into the record and continuing to oppose. The March invoice that includes a report in the original hearing specifically asked if there was a basis for sanctions. And when we became aware that Ms. Garramone had perjured herself, that there was an affiant available who was in the car, saw her driving while she was intoxicated, that we had both the request of the court that we look, or the court's existing question about whether there was a basis for sanctions. We also, as attorneys, had our ethical obligation to report that to bring that information into the court's attention and let the court do with it as it will. But that was not discovery into whether Ms. Garramone was damaged by these issues. It was really directly within the core of the TPPA. I think it's important to recognize here that Commissioner Garramone did everything that the TPPA was enacted to prevent. She was a public official running for re-election. She was unhappy with public attention to videos of her engaging in unlawful behavior, to videos that showed a policy by the local police of ignoring and voiding tickets related to public safety for public officials. She verified and filed a false complaint against Mr. Patrick, wasting the court's time, abusing that privilege of coming into open court. She ignored opportunities to end this litigation that are documented in the record, and she tripled the cost. The statute is designed to make sure that someone like Mr. Patrick, who is sued in a campaign stunt that goes to the absolute core of free association, of First Amendment protected activity, that he doesn't have to just back down. He doesn't have to just take it. Mr. Patrick has, we haven't talked about the reasonableness of the fees, but the court found that those fees were reasonable. Mr. Patrick has paid those fees. He had the ability to move forward and defend his good name against a politician who was doing exactly what the TPPA is designed to avoid. That the end result of it can't be that he has to choose between foregoing the $27,000 that he had incurred in fees and costs at the moment when she decided the game was not worth her candle, or incurring tens of thousands of additional dollars that will not be repaid. The plain text of the statute tells us that the recovery is for the reasonable fees incurred in filing and prevailing upon the petition. And the filing time is clear. The prevailing occurs when Mr. Patrick gets a judgment from the trial court that he can enforce, or as Nandagam tells us, if it goes up on appeal, and he's successful through the successful appeal. I think it's particularly telling that the foregone conclusion test really is a trap here. Because even if it is a foregone conclusion, it's hard to understand why Ms. Garramone is continuing, even in her briefs now, to argue that she should have no liability. That was an argument that was made in her brief to this court. It was made in the second hearing on the TPPA petitions. This was something where Mr. Patrick was along for the ride. And the TPPA says that it shouldn't be at his risk. Certainly the trial court could have granted Mr. Patrick's petition as soon as Ms. Garramone failed to put the material into the record that would support it 5 days before the original hearing. The court could have looked and said that while Flade might impact the other separate appeal, that it would not have any impact on Mr. Patrick's and grant his and let the rest proceed. That Ms. Garramone could have gotten off this ride at any point by responding to Mr. Ernest's letter before the petition was filed, by responding to my offer to end the litigation and settle up based on the existing costs. It was her choice, and the legislature made it quite clear that the consequences of that choice follow her, that Mr. Patrick should not be at risk, he should be made whole, and if anything, the statutory text looks at going beyond making someone whole and considering sanctions. It is a broad text, a broad statute that's meant to be read broadly. I see that I'm running up on the end of my time.
All right,
so
you'll have time for rebuttal. Thank you.
Thank you, Your Honor.
Good afternoon.
Good afternoon. George Davis here for Dr. Joe Kurtzinger. Ms. Garramone was Commissioner of Nolensville seeking re-election. There was evidence of abuse of power by Ms. Garramone in at least two ways: ticket fixing and driving while intoxicated. However, constituents, and particularly 4 constituents, were vocal in their opposition to Ms. Garramone. They made public several police cam videos obtained by the Freedom of Information Act showing evidence of ticket fixing and intoxicated driving, and disseminated those videos to all that would be interested. They also spoke out during the election process of their opposition to Ms. Garramone. It was then that she retaliated by filing a slap civil lawsuit against the 4 constituents, alleging false light and intentional and negligent infliction of emotional distress and civil conspiracy. In filing that suit, Ms. Garramone was abusively using judicial process to punish voices that were politically against her, voices that sought to bring to the voters' attention the abuses of her political position. not to be undone, Ms. Garramone additionally filed an order of protection case against my client, Dr. Joe Kurtzinger, in order to preclude him from attending the town hall meetings. That issue is for another appeal that will be before this court. The above actions by Ms. Garramone are clear violations of TIPA. TIPA's purpose is the safeguard of the right of petition, the right to speak freely and to participate fully to the full extent of the law. The interesting thing is the legislation doesn't always include the purpose in the legislation, leaving it for the courts and attorneys to argue what the purpose is. Here, they clearly stated the purpose as follows. This chapter is consistent with and necessary to implement the rights protected by the Constitution of the Tennessee Article 1, Sections 19 and 23, as well as the First Amendment of the United States Constitution, and shall be construed broadly to effectuate its purposes and intent. We believe that is the directive laid out by the legislation, to construe this section of law broadly to effectuate its purposes and intent. We believe that is the task that is put to this court, to construe TIPA broadly to effectuate its purposes and intent. In the facts of this case, Ms. Garramone has been found guilty of TIPA violation as to defendant Jason Patrick. The actions to the other three defendants did not differ. Their only difference was their failure to file a motion for summary judgment. The trial court stated that it finds Mr. Patrick presented a prima facie case of his legal action related to his free speech under TIPA. The court finds that Ms. Garramone failed to present a prima facie case on her claims of false light and infliction of emotional distress. One defendant filed a motion for summary judgment. The other three defendants instead relied on existing rationale laid out in Adamson versus Grove that the TIPA petition would be treated as a counterclaim. During the course of this litigation, the decision in Flade versus City of Shelbyville was published and held that a non-suit dismissal extinguished any TIPA petition or claims. We disagree and believe that Flade will be overturned by the Supreme Court.
And with that thought, should we wait for the Supreme Court to decide the issue, or should we marshal on and hope we come to the same conclusion that they might?
It's an excellent question. Later in my narrative, I was going to ask more orally that this court delay at least this portion of the decision until after Flade is decided by the Supreme Court.
Typically, and there's no rule or firm policy, but if we are aware that the Supreme Court is considering an issue that's arguably on all fours,
right,
then we will typically wait. There are exceptions to that, especially if time is of the essence, or if there's some other issues that need to be addressed. But this one appears to be right on the numbers with Flade. As far as your claims are concerned, Mr. Patrick's are different.
Yeah, and we have no problem with splitting the decision if you wanted to enter a partial decision as to his claims.
Yeah, we typically don't do that, but
okay.
But there's always an exception. Now, is it fair to say the question in your case is whether the petition, the TPPA petition, is a claim and or whether there is a vested right here that is an exception to a Rule 41 voluntary dismissal?
Well, it's interesting. I think there are three cases that have taken three different approaches to how to treat a non-suit in the midst of a TIPA claim. The Adamson versus Grove said they would treat a TIPA petition as a counterclaim. The Nandagam Neurology versus Beavers would treat the TIPA petition as a motion for summary judgment. And let's see what I missed, the Arbor versus Upchurch. The court held that TIPA fits so clearly into Rule 40.01, very beginnings exception that says that renders a plaintiff right to non-suit subject to the provisions of any statute. So you got three different approaches. Is it an exception to 40.01? Is it a counterclaim, or is it a motion for summary judgment? And I think I think any of those approaches carry out the directive of the legislature in TIPA to construe this section of law broadly to effectuate its purposes and intent. We argue that the TIPA petition in the context of non-suit must preclude the offending party from escaping attorney's fees and sanctions by filing a non-suit. In the Flade brief file that I submitted asking you to take judicial notice, there was one filed by several journalistic entities noting that other states, in particular Texas, Georgia, California, have provisions that enforce the fee award provisions when a plaintiff voluntarily non-suits while a SLAP petition is pending. So the goal of SLAP suits like anti-SLAP suits like TIPA are to deter SLAP lawsuits, are to provide expedient resolution, and to recover legal expenses. And then in the case of TIPA, it also provides sanctions to deter repetition of SLAP lawsuits. Those goals are severely thwarted if this court were to allow a party to file a lawsuit to crush or deter public participation in free speech, only to non-suit when they've clearly achieved their litigious abuse outcome. Here, Garramone waited until after the election to dismiss her suit. Why did I motion the court to take judicial notice of Flade appeal to the Supreme Court and the Supreme Court's granting review of the Flade appeal? The Flade decision to dismiss TIPA claims went against several cases discussed above, the Admonson versus Grove case, the Nandagam Neurology versus Beavers, and the Arbor versus Upchurch. I suspect the Supreme Court will clarify the issues that are before this court today. The main issue in Flade and here is whether TIPA provisions survive a Rule 40.01 lawsuit, or non-suit. We ask by oral motion to this court today to consider the arguments and the law laid out more articulately than I have made in the Flade appeal, and that this court delay any decision until the case, until the Supreme Court hears the case and rules on the Flade appeal. I think this will conserve judicial economy. We ask this court to consider the case law laid out in Admonson versus Grove, Nandagam versus Neurology versus Beavers, and Arbor versus Upchurch, which all support the protection of free speech. We ask the court to follow a broad interpretation of TIPA to allow continuation of fee shifting and sanctions aspects of TIPA beyond a non-suit. By doing so, this court will fulfill a broad interpretation called for in the TPPA statute.
All right, thank you, Mr. Davis.
Yeah.
We'll hear from you further on rebuttal. Good afternoon.
Good afternoon. May it please the court, Kristen Johnson on behalf of the appellee, Lisa Garramone. I would first like to address a jurisdictional argument that was raised in Mr. Patrick's reply brief, arguing that we did not timely assert the issue of whether Ms. Garramone had an absolute right to voluntary non-suit her claims against Mr. Patrick with prejudice while his summary judgment was pending. In his reply brief, Mr. Patrick relies on TCA 2017-106. This statute requires an appeal of an order dismissing of a case pursuant to a TPPA petition within 30 days. We are not appealing the dismissal pursuant to his TPPA petition. We are raising this issue of whether the trial court erred in refusing to dismiss the case pursuant to a voluntary non-suit. The trial court held in a case management order filed December 5 of 2022 that Ms. Garramone's notice was barred. And then the court again held that the non-suit was barred in its order on April 17, 2023. This court recently, last month, just held specifically that orders denying an entry of dismissal with prejudice while TPPA petitions were pending do not fall under the scope of TCA 2017-106, which is the statute that was relied upon in Mr. Patrick's reply brief. And this was in Kent versus Global Vision Baptist. Therefore, we would argue that Ms. Garramone can assert this question of law, whether the trial court erred in failing to dismiss the case pursuant to her voluntary non-suit with prejudice. It is in the rules of appellate procedure that appellees may raise issues in their brief, and that would be our first argument. This lawsuit could have been over on November 18, 2022, when Ms. Garramone filed her notice of voluntary non-suit with prejudice. It is our position that the trial court should have allowed this and considered the with prejudice aspect of her non-suit. Pursuant to the plain language definitions of with prejudice and without prejudice, she sought to dismiss her claims forever. There was no threat that she would assert these claims again in a non-suit without prejudice, which she could have done under the rules of Tennessee. Instead, she could have dismissed, she was seeking to dismiss these claims forever. Tennessee law already applies a liberal standard to voluntary dismissals without prejudice under Rule 41. It stands to...
You wouldn't disagree that a summary judgment motion pending does limit a right to voluntary non-suit, right? At least with regard to Mr. Patrick, there was no longer a right to voluntarily dismiss without prejudice.
Our argument, yes, our argument is not that she had a right to dismiss without prejudice, but the dismissal was with prejudice. Which is not explicitly stated in Rule 41. Rule 41 is regarding voluntary dismissals without prejudice. So I would agree if her voluntary dismissal was without prejudice and a summary judgment motion was pending, then yes, Rule 41 would apply and her non-suit would have been barred. But this was with prejudice, and we would argue that that distinction should have been considered here. In its order, the trial court relied on Perswani which is indicated in the brief, to say that to rely on this idea that there shouldn't have been a distinction between the two, but Perswani doesn't analyze the issue further because the parties in that case agreed that Rule 41 would apply. So what we are asking this court to do now is to find that there is a distinction between a non-suit with prejudice and a non-suit without prejudice. And I would also point out that the factual arguments that the defendants are making against Ms. Garramone are irrelevant. Courts are not supposed to consider the reasoning a party makes in exercising the right to a non-suit. This has been settled before in the Tennessee Court of Appeals, and that is indicated in case law in the brief as well. Finally, I would argue that the trial court did not err in awarding Mr. Patrick only a fraction of his requested fees. The amount of an award of attorney's fees is within a trial court's discretion, and it should not be reversed on appellate review absent an abuse of that discretion.
Counsel, in looking at the trial judge's order, it seems like, maybe I'm misreading the order and you can correct me, it seems like some division is being drawn between further discovery that was occurring, maybe sort of additional work on the merits of the case. I'm wondering, though, why that isn't part and parcel of the TPPA claim. I mean, the merits are a core part of determining whether you grant a TPPA petition or not. So, and maybe I'm just misunderstanding that part of the order, and that's not the distinction the trial judge was drawing. But if it is, aren't the merits analysis, discovery part of bringing forward and supporting your TPPA petition if you're the parties raising that petition?
Yes, Your Honor. I would point to the plain language of the statute, which says 2017-107. The petitioner is awarded expenses and fees incurred in filing and prevailing upon the petition. I would argue that...
But as part of prevailing upon the petition, don't you have to get into the merits of the case? And I'm looking at, for example, 2017-105D. The court may base its decision on supporting and opposing sworn affidavits stating admissible evidence upon which the liability or defense is based and on any other admissible evidence presented by the parties. And the sort of backwards, the burden shifting framework the court has adopted and has implemented in analyzing TPPA claims, those are deeply immersed in the merits of a case. And maybe I'm misunderstanding the trial court's order, but if that's the distinction that's being drawn between further merits discovery work that was going on by the TPPA petitioners in this case versus what they had done prior to a particular date, it seems like all of that merits is relevant under the TPPA. So I'm wondering why it's not part and parcel of prevailing upon the petition.
I would argue that the additional discovery simply did not help the petitioner prevail in his petition, because this additional discovery was filed much later in February, when the hearing was already held on December 15, and then when we had our other hearing in March, the court did not even hear and rule on the motion to amend. So since this was a motion to amend that was never even granted, the petition was never actually even amended. So that opposing affidavit, and I would also like to address this affidavit, it did not prove perjury on behalf of Ms. Garramone, but merely provided a rebuttal witness, which would have been a question of fact for the court to decide.
What about opposing counsel's argument here, though, that essentially Ms. Garramone kept litigating this case? And if she's going to continue litigating it, then they have to respond in order to prevail upon their TPPA, potentially. I mean, they don't know exactly what basis the trial court's going to decide upon.
Well, she tried to discontinue litigating the case back in November, and the parties did not agree to a stipulation of dismissal. Mr. Patrick would have if she had paid his attorney's fees, but because these were pending petitions, not even ruled on yet, it was Ms. Garramone's in our position that she should not have to pay for his attorney's fees. But regardless, this case became, after filing this voluntary notice of non-suit with prejudice, Ms. Garramone was forced to continue prosecuting the case because the court said that it was barred and the defendants did not agree to stipulate to a dismissal.
Doesn't the wording of the TPPA require an award of all the attorney's fees? Doesn't it say shall or something?
It does, Your Honor. It does have mandatory language, but specifically for fees incurred in filing and prevailing on that petition. And we would argue that a lot of these fees that were incurred after December 15, when this hearing on the petitions were held, did not actually help the petitioner prevail upon his petition. And so because they were outside of that scope, we would argue that the trial court was correct in narrowing it to those fees that were incurred in actually filing and prevailing upon the petition.
So you're agreeing with the trial judge's conclusion that it was a foregone conclusion as of that point, so there was nothing further they needed to do to prevail?
Yes, Your Honor.
But weren't they entitled to pursue their claim for attorney's fees and costs? And that was opposed by your client.
I would argue no, Your Honor, because Tennessee law is clear that a TPPA petition is not a counterclaim. And the TPPA statute specifically states that TPPA petitions do not create a cause of action in their own right, which is what counterclaims do. So I would argue that these were pending petitions that were not even ruled upon at the time she filed her voluntary non-suit. So I would argue that these were not causes of actions in their own right that they were entitled to continue to pursue.
In listening to your argument, counsel, can you prevail here if you're wrong about the voluntary dismissal argument that should have been able to dismiss with prejudice since it wasn't, well, with prejudice since it wasn't without prejudice? If that goes away, does everything else fall with it? And does the rest of the argument, and if there wasn't an ability to actually dismiss it at that stage, if the limitation was proper in terms of summary judgment, motion was pending, doesn't that make everything else completely reasonable by the opposing party in terms of the further litigation in this case? And isn't that the stool on which your argument has to stand?
I would argue no, Your Honor, because the only reason, assuming that this dismissal was not supposed to be effective, then it would have gone on summary judgment. The fees that were incurred were on amending the petition and opposing our motion for reconsideration after Flade came out, and they were not incurred in addition to ruling on this summary judgment.
anything further?
Yes, based on the plain language of this statute, we would argue that the trial court correctly narrowed those fees. Thank you.
Yeah. All right, thank you very much. All right, we'll hear from Mr. Sheehan. He has 3 minutes for a rebuttal.
Thank you, Your Honor. I agree.
If you would clarify your position on why you believe the appellees raising one of the issues is time barred.
Your Honor, I'm happy to let the court consider that if it would like to. This statute has been treated in different ways, and the language that makes the appeal as of right under 107 has been interpreted by the court to require it to happen within those 30 days. This is really a heads we win, tails they lose argument, where even if the court considers it, there's absolutely no argument that Rule 41 would apply to Mr. Patrick. The key points that I think are worth noting here is that Ms. Garramone kept litigating, and she is litigating now still. Mr. Patrick at no point in time had the option of taking his fees and walking away. He was ordered to come back to re-argue this case by the trial court, and he had to comply. He had to have his counsel prepare for it. He was, when we look at what the trial court actually did, I think that Judge Usman is exactly right, that the trial court looked for that moment where Ms. Garramone tried to stop litigating. And you can compare the numbers. You can look and see that the costs awarded were not the costs awarded through the first hearing. They weren't fly-specced and carved out. The trial court looked and said, we've got a kind of similar statute that says there's a $10,000 cap, and it seems like Mr. Patrick should have given up and gone home, so we're gonna kind of double it. But it doesn't include even the costs that he incurred for the trial, for the court reporter at the first hearing on this. It's clear what the court did when you look at the numbers that were used and where they came from and what was instructive. I think that while Mr. Patrick would like this case decided instantly and doesn't have a hard argument on Rule 41.01 as it applies to anyone else, it's worth noting that the statute itself, the rule itself, says that it does not apply, it has except when a motion for summary judgment made by an adverse party is pending. And under any reading, Mr. Patrick was an adverse party to Ms. Garramone. That his summary judgment motion was pending, and she had no right to invoke Rule 41. If the court looks at page 140, which is her notice of voluntary dismissal, I would ask the court to look at that and see whether the trial court erred by saying that this does not apply. The trial court gave it its best shot to find a way that it might. That it doesn't invoke any rule, it doesn't invoke any equity, it simply says, I'd like out. And while Rule 41 is broad, and it lets I'm sorry, Your Honor, my time's expired.
You may finish your thought.
Well, Rule 41 is broad, and it allows a plaintiff in Tennessee courts the right to do almost anything to dismiss the claim. It doesn't allow them to do that. This is the one clearest thing that 41 doesn't allow. And she is still arguing, still forcing Mr. Patrick to incur legal costs. If this case is not the one that allows a defendant to be made whole under the TPPA, it is a dead letter, it is a useless statute. Since it can't be that, Mr. Patrick respectfully asks the court to reverse the July 2023 judgment below and remand with instructions to award Mr. Patrick the full value of the court costs, reasonable attorney's fees, discretionary costs, and other expenses he incurred in filing and prevailing upon his petition, including the costs and fees incurred through this appeal and on remand.
All right, thank you, sir.
Thank you, Your Honors.
Mr. Davis, you have 2 minutes for rebuttal. You're going to yield it? All right. Thank you, sir. Thanks to all three of you for your arguments. You've presented a lot for us to think about, and we'll take it under advisement. Thank you. You're free to go.